afternoon, some members of the Ghana Bar Association have slammed leadership of the association for allowing the passage of a resolution calling for the reinstatement of suspended Chief Justice Gertrude Torkornoo. On Tuesday, the GBA published the reasons behind the resolution voted for by its members present at the mini-bar conference in a communique. Now, the Ghana Bar Association says the president did not publish a constitutional instrument guiding him in the decision to suspend the Chief Justice. Private legal practitioner Ni Omanyeboni Lamte says the conduct of the GBA on this matter brings the name of the association into disrepute.
Of the Constitution are not oblivious of 296C when they provided Article 1462. They said the procedure is restricted to 146. They are the framers of the Constitution. They have made Article 296C. And so I think they are very much aware of it when they provided Article 1462. The effort being made to import Article 296C into 146 is unconstitutional. But granted that that is not the position of the law, Article 296C has already been interpreted by the Supreme Court. So the GBA ought to have averted its mind to that interpretation. And I don't want to believe that the members of the GBA who gathered at the Labadi Beach Hotel and took these decisions do not know about the position of the law, the position of Article 296C.
More on this, another lawyer, Alfred Papadakwa, says the GBA's resolution suggested that the president should have ignored the advice of the Council of State, to suspend the Chief Justice.
The president was acting upon the advice of the Council of State. Yes, that what it actually means is that it was based on the advice of the Council of State. So the GBA as an organization cannot come and make a point that the president should ignore the advice of the Council of State. That is actually what the GBA is saying, that the president should ignore the advice of the Council of State, which I find it very, very unfortunate. Now, number two, you would also realize that there is actually a pending application for the suspension of the order for suspension, or however you call it, at the Supreme Court. I stand to be corrected, but there is actually an application which was filed by Vincent Sifua on that matter. Now, if the GBA, which earlier on had issued a communique that we should be mindful on some of these discussions because the entire matter is sub judice, and just a few days after the GBA, knowing very well that this matter is sub judice, comes out to now flout its own directive and make the point that the president should revoke the suspension. What it actually means is that the application now pending before the Supreme Court, which is to be heard later on in the month, has already been determined by the GBA, which is quite unfortunate coming from the Ghana Bar Association.